Let me ask you, attorney involvement for projects in contract review.
Right.
Do you think there's a threshold?
You know, it's interesting. One insurance agent told me once that contracts for 10,000 and up are the ones that are litigated the most. I think that might be a little bit of a low threshold, but I'd say if you're 50,000 plus, for sure. I like to use the AIA family of contracts because it's well known in the construction industry. The A107 is my favorite. It's the middle form between the A105 and the A101, 201. It has a lot of things in there that don't apply, but fine. If it doesn't apply, you just don't apply it. And then where I do my job is the supplementary conditions or the addendum. So I do recommend, if it's a balcony job, paving, painting, roof, where there are bigger ticket items, for sure. Now, yes, if everyone did what they say they're going to do, and a handshake really meant what maybe it did 100 years ago, you wouldn't need me, and I'd be probably doing something else. But I think associations really are a little short-sighted. They lean on people they shouldn't. They put their CAM in a compromising position and have the CAM review the contract, or their engineer. And engineers are not licensed attorneys. They think they can put a form together with an addendum and say this is what we recommend, but they're really practicing law without a license. So we try to train our clients, use us, let us be involved in preparing the notice of commencement. That's an important document. That's a critical document at the onset of the job, and if it's not done right, I've had a situation where the association may be doing HOA common area road work, and the notice of commencement defines the whole plat. And the plat contains not just common areas, but people's lots and people's homes. So if the notice of commencement describes the entirety of the plat, because no one was paying attention to legal description, and there's a lien file, guess what? Every unit now is liened. If the legal description was the common areas known as tract H of plat XYZ, then that's where the lien goes. It goes in the common area, does not affect the lots. So that's a very important document. It costs near nothing for the lawyer to prepare it. I'd say 1 in 1,000 projects I'm asked to prepare it. I suggest I prepare it, but they're trying to cut corners, and very often cutting the corners work. I mean, there's such thing as getting lucky. But if there's a dispute and the contract is short on the remedy or the detail isn't sufficient, then the association is going to be battling a losing case. So a little money spent up front makes sense in the long haul. So if it's 50,000 plus, it's probably something I'd recommend. Maybe even lower. Some associations have me do lower ones. You're talking a few thousand? No. Maybe in a few thousand, I'll do a short addendum to cover certain things that I need to cover, like insurance and draws, and something interesting about insurance. And the accord form is what agents use to indicate what insurance coverages are being placed on the property. It used to be on page 2 that no one got to see. Now it's at the top of page 1. You probably know what I'm about to say. Without a proper endorsement, you're not additional insured. Now they'll come back and say, oh, but the policy says anyone under contract with my insured, they automatically get conferred that status. I don't think that's enough. I think you actually, I insist on endorsements. On certificate holder, I want a scheduled endorsement so they know who you are and make sure that they don't miss you. Because if they don't know you're there, you're relying on someone to figure it out. So I do a lot of construction contracts, and I always have a few going at any given time. And one of my favorite things to do, in addition to amending documents, but I'm finding associations don't really know when to ask when they should.
Building a reliable contract that's going to protect the association.
Exactly, right.
You need to do that with everything,
yes,
including the policy that you're receiving, your annual policy, and also your contracts with your contractors.
Right.
And that needs to be backed up by the policy that the contractor has and the certificate that's issued to you.
Right.
And it may be included in the contract because your attorney told you it was, or you saw it in some part in there.
Right.
But if it's not also on the certificate correct,
right,
you have no idea. And if you're not additional insured, you can't check it.
Right.
I tell my associations, you receive a certificate, you asked
Right.
for these things.
Right.
You need to also be sending that to your attorney, they can check.
Yes.
Because you're additional insured.
Yes.
I can also check
Right.
for that contractors to verify if they have the coverage that they say they do.
Exactly.
If you're listed as additional insured.
Exactly.
Which should be the very minimum.
Well, that's
you
why
should
by
be
getting the
asking for.
endorsement, you know for a fact you're endorsing an existing policy that
Right.
exists. Right?
Well, if you're additional insured, you have access to all their policies.
Exactly.
So we can know right then what they have and don't have.
Another thing I'm finding, and I can go on construction contracts forever, but manufacturer's warranties. Very often when a project is closed out, someone doesn't think as part of the last draw to make sure all manufacturer's warranties are in place and issued without qualification. It's a missed detail very often. So now, later on, there's a claim, we believe it's product related, but the contractor that also warrants the product, they're out, they're either in trouble or out of business. You go to the manufacturer, we want you to honor this warranty. He says, what warranty? We never issued one. Well, the contractor said we're going to get one, yeah, but that's the contractor, we're the manufacturer. So as part, I put in my project closeout provisions, one of them being make sure it's in place. Not one of those qualified ones, but one that's issued without restriction. So that's something that normally you'll have an engineer or architect overseeing the work. One of that person's jobs is to make sure all the closeout is done, and that's one of them. But where there is not a design professional, I make sure it's in the contract and impress upon the association, don't make your last draw without making sure whatever warranties from the manufacturer you think you're getting are issued and you see evidence of it. So you can then use that when you need it later on.